In clause 27, Amendment 108, Lord Moynihan of Chelsea.
My Lords, I apologise for being precipitate. I was trying to get you all home as quickly as possible. I rise to move Amendments 108 and 109 in my name. My declaration of interest is that I've worked in my career with hundreds of companies, many of which had to create redundancies at one time or another, a few of which had to go into liquidation. I am not an insolvency practitioner. The first of these amendments, 108, is a small but very important proposal. First on it, a disclaimer. I'm not seeking to alter the vast majority of what is proposed under Clause 27. Only that small minority of redundancy cases that occur when a company goes into insolvency. Also, I'm not proposing any override of TUPE legislation, in particular in so-called pre-packs. What I am proposing is that on a non-partisan basis, we take advantage of the passing of this bill to rectify a long-standing conflict between two separate laws, a conflict that often places insolvency practitioners in an impossible position. What is this conflict, my Lords? It is between the provisions of the 1968 Insolvency Act versus the 1992 Trade Union and Labour Relation Act, which latter act, as your Lordships know, today's bill seeks to amend. The conflict has long existed. It's not a function primarily of this bill we're discussing today. Let me explain briefly what it is. Insolvency practitioners are required to act quickly so that value is not eroded. The 1992 Act, however, requires consultation of between 30 to 45 days, which would utterly frustrate the imperative to move swiftly. So the liquidator is basically required to break one or the other laws, and always chooses to break the 1992 law, and will choose to break it as amended by this bill, because the liquidator has to act speedily, and a long consultation, whether 30 or 45 days, would be impossible, is always found to be impossible. As a result, ambulance chasers write offering, quotes, free money to all employees because the law has been broken, and therefore the provision comes in that penalty money should be paid to these workers. This does not happen in all cases, only when trade unions are involved or the insolvency is large enough for the no-win, no-fee crowd to move in. Much of the money in bankruptcies then ends up in the hands of lawyers rather than any of the creditors. Note that in most non-liquidation situations, these stringent provisions make such such penalty awards rare. An employer would be foolish to flout the requirements only in liquidation, where the liquidator is essentially forced to choose to flout one law or another. Allow me, my Lords, to offer here briefly the relevant background to that important national institution, the Insolvency Service. In the UK, there are around 1,500 insolvency practitioners, but only some 800 of these actively take appointments at this time. It is one of the most highly regulated professions in the country. It has one of the most difficult exams to pass. So, to take the most recent example, in November 2024, of 172 applicants sitting for both exams, only 10 of them passed. And partly because of this, more IPs are retiring each year at this time than are qualifying. Now, my lords, insolvency professionals have to be a very tough-minded and resilient crowd, because of course it's always difficult to deal with the harsh realities of insolvencies. And there are many bad actors in this space who go to great lengths to frustrate the insolvency practitioner. They take personal suits against the IP. They make multiple complaints to the professional body to try to divert the attention of the IP. There are long, drawn-out wars of resistance from those trying to resist bankruptcy. IPs, finally, have very few funds with which to pursue the bankruptcy, let alone defend themselves against these depredations. So we need to ensure, my lords, that we protect this important national institution. We should seek to make their life easier and more sensible when lacunae such as this are discovered. We need to understand that a collapse in this institution could create chaos in the corporate landscape, with a free-for-all, with lawyers, creditors and bailiffs running riot. That well-known book, Why Nations Fail, points precisely to the collapse of institutions as the cause of national decline. So then, let me give the recent go-centric bankruptcy as an illustration of the precise reality of what happens in real life, rather than the imagined situation that governments have been persuaded will be the case. Go-centric, a Glasgow company, went bankrupt, owing some £5 million to employees, to HMRC, to trade creditors and others. £600,000 was owed to employees in redundancy, sick pay and so forth. £637,000 were available, so the employees received all that they were due. But in doing this, there was no consultation, so immediately ambulance chasers wrote to these employees saying, we've got some free money for you here if you take, actually the government, to the employment tribunal, which they did, and the employment tribunal awarded the 90 days penalty money, which is the maximum then that could be awarded, another £600,000 for these employees. Governments are told that there will be mitigation by courts, but there never is mitigation. No one came to argue for mitigation, not the redundancy payment service, which had to pay the money, and certainly not the insolvency practitioner. It was not their concern. HMRC, via the redundancy payment service, was therefore out by £600,000, and that meant in the end, the taxpayer was out £600,000. With Clause 27 of this new bill, this taxpayer-funded amount would rise to £1.2 million. Note that this is on top of the £600,000 that the employees received in redundancy money. And it's really the only occasion when this would happen, because no employer would be so stupid as to incur these fines, only in a redundancy where it is necessary to go against the law, as I've explained. Now, my lords, I have no personal interest in this matter, but looking to get a bipartisan solution, I wrote to the Noble Lady Jones, the Noble Minister, reviewing this dilemma, and she very kindly, as indeed she's done throughout this whole period, offered to meet, met with me along with the Noble Lord Leong and the Noble Lord Cates and others, and subsequently sent a written response to my letter, which made it clear that she recognised the problem but felt no change was needed. In particular, her response stated, consultation could still, she felt, take place. Secondly, in the law, employers are allowed flexibility, and courts will take that into account to make smaller awards. What she called the redundancy, her letter called the redundancy protection service, it's actually the redundancy payment service, will cap payments at 8%. So it was a kind and thoughtful response, but the response seemed in several places to conflate insolvency practitioners with employers. The two are very different things. The liquidator, for example, usually has no prior knowledge whatsoever of the company they deal with. Some half of the letter talked about employer obligations, but the employer is no longer involved once a liquidation is called in. In any event, this response, as I discussed in the Go-Centric case, did not reflect the reality of what actually happens in a liquidation. The insolvency practitioners have no reason to spend money attending employment courts. Much the same is true for the redundancy payment service. So at the employment court, it is a free-for-all between the activists and the ambulance chasers. Whether because of this or not, I'm told by insolvency practitioners that none of them have ever seen less than the full 90 days, soon to be 180 days pay, awarded on top of redundancy money. I cannot but believe, my lords, that this is just a mistake. The situation is complicated by the creation of the new Fair Work Agency, and I believe it's poignant, my lords, that we are discussing the creation of a new regulator the day after the Chancellor of the Exchequer described regulators as a boot on the neck of business. Does the government at this end of the House talk to the government at the other end of the House always? Will the new regulator make the situation even worse for insolvency practitioners? I ask the noble Baroness, the Minister, to give assurances that this will not be the case. So, to summarise, my lords, my amendment merely seeks to carve out insolvency situations from clause 27. The liquidator will then not have to break the law will as a result reflect reality, and the large majority of redundancies will not be affected. Finally, while on my feet, I also, my lords, need to move Amendment 109. In doing this, very briefly, I feel myself to be acting on behalf of the government's Chancellor of the Exchequer, who, as I mentioned, said yesterday that regulation is a boot on the neck of business. So instead of having clause 27 worsen the burden of business, increase the pressure of that boot with its 30 to 45-day delay before dismissals can take effect, I propose that the delay be reduced to 21 days. My lords, I beg to move amendments 108 and 109.
Amendment proposed, clause 27, page 48, line 13, at end insert the words as printed on the martial list.
Lords, we on these benches do not support these amendments. The obligation to consult collectively in redundant situations is a vital safeguard for workers, providing them with a voice and an opportunity to understand and respond to proposed job losses. Reducing consultation rights, especially during the turmoil of insolvency, will leave employees even more vulnerable at the time of significant uncertainty. Similarly, cutting the notice period would deny workers essential time to plan, seek advice, make necessary financial and personal arrangements, and we believe strongly these protections must be preserved and not weakened.
My Lords, we are very grateful to my noble friend Lord Moynihan of Chelsea for his amendments in this group, and I would like to thank the noble Baroness, the Minister, and her team for the way in which they have entertained and thought through some of the key points made by my noble friend. As he rightly pointed out, collective redundancies are sadly not uncommon in cases of employer insolvency. In such circumstances, the role of the insolvency practitioner, which he's outlined so clearly, is both time-critical and highly constrained. The legal duties placed upon them can come into direct tension with the obligation to consult collectively with employees, a tension that is not merely theoretical, but is borne out time and time again in practice. And if I would just say to the noble Lord, Lord Goddard of Stockport, that the amendment does not seek gratuitously to diminish the rights of employees. What my noble friend has done is to bring the government's attention to what is a genuine gap in the law, one that has become more acute in the light of the changes that this bill introduces. As it stands, the duty to consult can place insolvency practitioners in an impossible position, bound by law to take urgent decisions to preserve value or manage a collapse, whilst also facing legal jeopardy for failing to comply with collective consultation obligations that were not and never were designed with insolvency in mind. We have to be realistic in this situation, and where a company is collapsing, consultation, however desirable, cannot always be carried out in the prescribed way. It's in nobody's interest, least of all that of employees, to put insolvency practitioners in a position where they are forced to choose between compliance with employment law and their fiduciary responsibilities. So I do believe the government should take my noble friend's argument seriously. This is not a theoretical concern, it's a matter of practical urgency. So I therefore urge the noble Lord the Minister to reflect carefully on the implications of this clause and to engage with my noble friend's proposal in the constructive spirit in which it is offered.
My Lords, I'm grateful to all noble Lords who have spoken. My Lords, Amendments 108 and 109 tabled by the noble Lord Moynihan of Chelsea amend Clause 27, and I would like to thank the noble Lord as well as noble Lords Lord Sharp of Epsom and Lord Hunt of Wirral for their engagement on this matter when we met previously. Turning first to Amendment 108, the clause as drafted does not alter how collective redundancy obligations apply to insolvent employers. It is right that where employers know that their business is in trouble and that redundancies will be necessary, they should be required to do so as much as possible to collectively consult on those redundancies. That was the case before, and it will be the case after this legislation comes into force. So nothing has changed. Employers should consult when they propose to make a qualifying number of redundancies, and they will face penalties if they do not. However, crucially, as my officials and I previously discussed with the noble lords, those penalties are set by a tribunal who will take into consideration the seriousness of the employer's default, as well as any mitigating factors. The amount set out in legislation is a maximum award, but tribunals may award less where the employee or where the employer or insolvency practitioner has taken all reasonable steps to consult for as long as possible in the circumstance. Section 1887 of the Trade Union and Labour Relations Consolidation Act 1992 already affords flexibility for employers who cannot fulfill their collective consultation obligations. It allows employment tribunals to assess on a case-by-case basis where there are special circumstances which make it not reasonably practical for an employer to comply with their collective consultation obligations. This amendment would leave employees whose employer has become insolvent without the protections that are already in place, and that have been in place since the Trade Union and Labour Relations Consolidation Act 1992 entered into force. My Lords, this would also lead to a two-tier system of rights, where if an employer was becoming insolvent, affected employees would not be afforded any collective consultation, meaning they would have fewer rights than any other employee. This could be in situations where collective consultation is most important and impactful. It is right that employees who are made redundant, often in precarious circumstances, are prioritized and have access to sufficient remedies. Employees should not suffer to improve business value or in order to benefit other creditors. My lords, this afternoon I looked at the R3 website, and one of the concern that they had with this particular amendment is that it will devalue the business when it's valued as an ongoing basis to a potential purchaser. And why should employees actually suffer because of that devaluation? My lords, turning now to Amendment 109, I would like to inform the noble lord.
I apologise, noble lord. Was he saying that R3 stated themselves as being against this amendment?
Sorry, the R3 website said that they are pretty much they're concerned about this amendment because it may devalue a company's valuation as an ongoing basis because of all the day one rights accorded to employees. That's what they said on the website.
I hate to stay the House longer, but I'm in ongoing discussion with R3. They've never said this. Are you quite sure they're not saying they're concerned about the clause rather than the amendment?
I may be wrong, but it's just on the website. It's either a clause or amendment. But sorry, I think it's a clause. Sorry, it's not your amendment. It's the clause. Oh. Right. I apologize for that. Well, it still bears the same thing. If they are against the clause, basically, they obviously are concerned because of the valuation of the business. So my point here is, why should the employees suffer? Because if they're not going to take into account all the day one rights. Now, turning now to Amendment 109, I would like to inform the noble lord that the notification period in the current law aligns with the consultation period. This means in practice that whenever an employer begins a collective consultation, they must also notify the Secretary of State at that point. Setting these periods at different times could cause confusion for employers and increase the risk of non-compliance. The objective of the notification provision is so that such notifications may be distributed to appropriate government departments and agencies who are best placed to support affected employees. This amendment would mean those agencies will be less prepared to support large volumes of individuals who have been made redundant. We have had extensive engagement with employers throughout the passage of this bill, and the timeline of notification has not been raised as a concern. Therefore, this amendment is unnecessary. My lords, may I take also this opportunity to say to the noble lord that we will engage with the Insolvency Practitioners Association, engaging with them and actually sort of obviously raising and discuss these issues that the noble lords have raised with them as well, and actually sort of listen to what they have got to say. So with that in mind, I ask the noble lord to withdraw Amendment 108.
I thank the noble lords for their patience in enduring at this late hour this somewhat arcane discussion. The noble Lord Goddard emphasised the importance of consultation, indeed the essential nature of it, and said how vulnerable employees are. But they are not vulnerable, my lords, in this particular circumstance. They have priority as creditors above all other creditors. If there is money, they will get it. If there is not money, they will get it from the redundancy payment service. But why, having got their full amount of redundancy money, should they then scoop the pot and get 3 times as much because of a flaw in the law which will leave, for example, small trade creditors not receiving anything, possibly facing bankruptcy, not to mention the fact that a lot of this money will usually come from the taxpayer. Ultimately, the source of those funds for these penalty payments. But anyway, via HMRC, in whom the redundancy payment service is, thus increasing that deficit. Just a mini black hole, if I could be so foolish as to mention that. My noble friend, Lord Hunt of Wirral, ably, in my view, reinforced the need for this amendment. The noble Lord Leong emphasised the importance of consultation. I understand that, but I believe Hansard will show that I already dealt with most items of his response. So I'm not going to delay noble lords longer by going over that ground again, except to say once again, he asks, why should employees suffer? They will not suffer. I hoped I had explained that. I'm chagrined to understand not. They have total priority above all other creditors in receiving their full redundancy payments. All I ask is, why should they, as a result of a glitch in the law, receive in total 3 times that much as a so-called penalty payment that won't be paid by the employer, because the employer is long gone, that won't be paid by the insolvency practitioner, if that's who you feel, in facing the impossible task of obeying both laws at the same time. Won't be paid by them. It'll be paid by us mostly, my lords, the first HMRC and through them the taxpayer. My lords, the hour is late, and so if only on compassionate grounds, I beg leave to withdraw my amendment.
Is it your lordship's pleasure this amendment be withdrawn? The amendment is by leave withdrawn. Amendment 109, Lord Moynihan, not moved? Not moved.